Okay, do you know what judge you're? No, no. No, what judge you're assigned to? Okay. That's just cool. Judge Giles. Do you have your case on? You have your case on? I can't hear you. Can you speak up? Okay, 000679470. 470. That's what I said. 470. Okay, start all over. Uh-huh. Oh, no, you're in front of Judge Bryant. It's not Judge Giles.
For prisoners.
No, yeah, you're scheduled for a review in front of Judge Bryant. Miss Bryant. So you're gonna have to log off and then log back on for Judge Bryant. She's in courtroom 339. Okay? Yes, you can do it that way. Just click on Judge Bryant. Okay, why don't you do this? Call the courtroom 313-965-2295. Okay, because that's the courtroom you should be. Correct. You're welcome. Good morning, Mr. Perkins.
Good morning. How are you?
Good, how are you?
Very well. Nice to see you both.
You too. What case are you on? Oh, you on Derek Johnson.
Yes.
Wayne County Jail. I was gonna see if they could bring a client out.
Hi.
Did you need a mom, Mr. Perkins?
No, I didn't. I got the
Oh.
discovery this morning.
Yes,
Right.
yes, from Wayne County.
I was thinking, can you bring Derek Johnson out?
Yes, we can. One-
Attorney Hamilton,
Good morning.
good morning. Who you here on?
Peterson?
Are you ready or are you waiving your client's appearance?
I'm gonna see if I can waive my client's appearance.
821-821-47. Peterson is, I don't have the files. I don't know what's going on downstairs, but it's starting to irritate me a little bit.
I was gonna say, it's two cases.
Yeah. Yeah, I've been looking for him.
Procedural and also registrar action, just to set a date.
Yeah, they- good morning, how are you? All right, you come across it. Thank you. All right, so I'm ready on Johnson. And you said do ROAs on Peterson, Judge?
Yeah.
Okay. I'm ready.
36th District Court, State of the City of Detroit, State of Michigan, now session with the Honorable Ronald Giles presiding.
Parties ready on Derek Johnson, calling case number 23-57607, the people of the state of Michigan versus Derek Johnson. Defendant is charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with a dangerous weapon, felonious assault. Count 3, count 4, weapons, felony, firearm, habitual offender. Third notice, this matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Morgan on behalf of the people, appeal number P86590.
Mr. Perkins,
Is muted.
you're muted.
Can you hear me now, Your Honor?
Yes, sir.
Okay, I'm sorry. Good morning, Your Honor. Good morning to your staff. May it please this honorable court. My name is Todd Russell Perkins, P55623, appearing on behalf of Mr. Johnson.
All right, Mr. Johnson, can you state your name for the record, please?
Good morning, I'm Derek Johnson.
Thank you, sir.
You're welcome.
All right, send this matter for exam.
Yes, Your Honor.
Okay. You're available 9 o'clock on July 12th?
No, Your Honor, I was gonna ask if the court might be available, I think on the 14th. If I'm late.
Yeah, I don't have a,
Yeah,
what's next Friday? Oh, wait a minute. Yes, I do. Nine o'clock on the 14th?
Could it be 9:30, Your Honor? I got a PCC in Farmington that it won't take that long. Actually, if that's really too much, if that's too obtuse, I can have somebody else do the PCC. But if 9:30 would work, I'd ask for it.
9:30 is fine.
Okay, all right. Thank you so much.
That's it.
more.
It's kind of narrow for you to walk through.
All right, anything else?
Oh, no, I was just waiting to be excused, Your Honor.
All right, that concludes the hearing. Thank you.
Thank you so much.
Have a good one. Have a good weekend.
Nice seeing you again. Have a great one.
Bye, Mr. Perkins. Have a good one.
Bye.
Did I?
Yeah.
So what just happened?
Oh,
Excuse me, is it possible I can talk to my lawyer?
Oh,
he already, went off.
Judge, I'm
He's
sorry,
no longer-
he didn't understand what happened.
What happened?
Okay, he'll get in contact with you, but I can't, I mean, right now, he went off of, Zoom. So he's no longer on.
What happened with court? I mean, what happened?
All right, you'll be able to talk to him about it. It's just, I can't put you on now because he's no longer on.
So I have another court date?
No, Judge, he's asking what's the next court date if his bond changed? That's what he's trying to see.
Next court date is, July 14th at 9:30. That's in person.
Exam,
Yes, sir.
okay, and no bond change?
No bond change at this point.
All right, thank you.
parties ready on Terry Peterson. Calling case number 2356873, the people of the state of Michigan versus Terry Peterson. Defendant is charged with count 1, breaking and entering a building with intent. Also calling case number 2357121, the people of the state of Michigan versus Terry Peterson. Defendant is charged with count 1, controlled substance possession, count 2, weapons carrying concealed. These matters are scheduled for a probable cause conference.
Good morning, Judge. Alex Swing on behalf of the people, number P86590.
And good morning, Your Honor. Vanessa Hamilton, P82107, on behalf of Mr. Peterson. Your Honor, Mr. Peterson is not here today. I'd ask that we waive his presence to set a preliminary exam date.
All right, court will waive his appearance for the purpose of hearing. Are you available December 12th at 9:30?
Yes,
Well, I said December. Gee, right. July 12th, 9:30, I'm sorry.
I didn't even notice, so I don't know what that says, but yes, both cases.
All right, thank you.
Okay, thank you.
All right, anything else?
Oh, good morning, Your Honor. I'm here. This is Attorney Robin McCoy here on Lemanuel Robbins. It's a PCC.
Okay, thank you.
Ms. McCoy, are you waiting on your client? Is your client in the waiting room?
I don't know, but I actually have a jury selection at 9. So if we could waive his appearance, I've already talked to him. He has discovery. We're asking for an exam.
Okay. Judge, this is another one I don't have a file on.
Okay, you do it.
Calling case number 2357605, the people of the state of Michigan versus Lemanuel Robbins. Defendant is charged with count 1, weapons, firearms, possession by a felon, count 2, weapons, felony, firearm, count 3, weapons, ammunition, possession by a felon, count 4, weapons, felony, firearm, count 5, weapons carrying concealed. This matter is scheduled for a probable cause conference.
Good morning, Judge. Alex Swing on behalf of the people, number P86590.
And good morning, Your Honor. Robin McCoy, P63057, on behalf of Mr. Lemanuel Robbins. who I will waive his presence for the PC, or requested his presence be waived for the PCC. And he has discovery. We've discussed his case. We're requesting a live exam.
All right. Are you available July 12th at 9 o'clock?
July 12th, 9 o'clock. Yes, Your Honor.
Anything else?
No, nothing further, Your Honor. You said 9 o'clock live exam. Okay.
Okay, yeah,
All right, Your Honor. Hope you and your staff have a good weekend.
you too.
Yes, why are you calling me? What problem? Okay, did you see my message? I just said name your device at the courtroom area. I can't let you in. If you don't name your device. What is your name? Yeah, you didn't name your device. And hold on, I don't see you on the docket. Did you call earlier and I gave you a number? You spoke with Judge Bryant's courtroom? Okay, you're not in Judge Bryant is in courtroom 339, not 233. Okay, that's why I asked, were you the person I talked to earlier? Your correct courtroom is 339, Judge Bryant, and the courtroom phone number is 313-965-2295. Okay, so call them. If you're having issues, you need to call that court. Okay?
Good morning, Madam Clerk. This is Brian Gagnick. I have Mr. Gregory Bird today, PCC.
Oh, I'm sorry. I did let you. I forgot I let you in. Can I have your P number, Counselor, please?
64220.
All right. Are you waiting on your client? Is your client in the waiting room?
I don't see that he is. I did not have good contact information for him, so I am waiting for him.
Okay. Did you want to wait or are you waiving their appearance?
I need to speak with him, so if it's okay, I'm just going to hang out. I have everything I need to ask for a preliminary exam when the time comes.
Okay, because let me see, because I got a couple people in there that I'm trying to tell them to name their device, so let me see if I can find out who they are.
Thank you.
Okay. Wayne County Jail, who do you have? Your name in Wayne County Jail?
Gary Parker.
Gary Parker. All right, thank you. We're just waiting on your attorney, okay?
Okay, ma'am.
Yeah, you want.
The courtroom. Yes. Okay. No. What did you send it to, the courtroom email? Oh, oh, yeah, I got it. All right, thank you.
Yeah. So there's one. That's just.
Good morning, counselor.
Good morning.
You're on Kareem May.
Yes,
All right, he's in Wayne County Jail.
yeah, he had a stroke Saturday and was in the hospital 4 days, and he's in a wheelchair when I visited him a few days ago. So it might take him a minute to bring him in. I don't know what to tell you, but he's awful sick. And he's a young
You
man.
wanna waive his appearance?
Oh, we could. I'm going to set it for exam. I wanted to address bond though. At least get DSU over there to look at him because, you know, like I said, he had a stroke. They put him in a wheelchair. It took 2 deputies to wheel him into the visiting room to see me. But we're going to hold the exam. I can tell you that.
Right.
Yeah, I'll give you this. It's first exam.
I'm sorry, Judge, I missed that. Is he waiving his clients or?
Yeah, he'll waive his time.
Yes, I can waive his appearance, but you know, at least get DSU over there to look at him, see what they're going to do with him. Maybe a medical release
Okay.
or something.
Okay, I was just asking the judge so I can call the case. Thank you. All right. That's Kareem May. All right, calling case number 2357620, the people of the state of Michigan versus Kareem May. Defendant is charged with count 1, home invasion first degree, count 2, malicious destruction of personal property, $200 or more, but less than $1,000. This matter is scheduled for a probable cause conference.
Good morning, Judge Alex Warren on behalf of the people, P number P86590.
Good morning, Your Honor. Daniel Finwall, P66421 on behalf of defendant Kareem May.
Waive his appearance for the purposes of this hearing, counsel?
Yes, Your Honor.
All right, thank you. All right, are you available July 12th at 10:15?
Yes, Your Honor.
What was that, Judge?
July 12th.
That's not enough time for DSU.
I don't think you can get a personal one.
Oh, that's for DSU.
I understand. I'm not going through that.
If I may, Your Honor, he told me that they had told him they may send him home on a tether, but it was confusing to me. I don't know if anyone's visited him or not, but so given the
Okay, yeah,
nature.
he has a personal bond with a tether. He's on house arrest. Can leave for court and medical only.
Okay,
So if tether is available, he'll be out.
okay, yeah, that's what I thought he told me. Okay, so bond's not an issue then. As soon as they get him out of there, I'll. Okay. All set then, Judge? We'll see you on the 12th.
Yep, we're all set. Thank you.
Thank you. And that'll be in person, Judge, right? For both of us, for the exam?
Correct.
Okay,
Yep.
thank you.
All right, thank you.
And the attorney? Oh, that's, Mr. Park. Barry Park.
How many folks have met? One more.
No, who was she the attorney for? What case?
Oh, she was on, Peterson,
What was the time?
9:30.
July 12th?
Yep.
Oh, both Peterson?
Yeah. Oh, Peterson?
No, the time is 12:30.
No, 9:30.
9:30, that's what.
For Peterson, 9:30.
I know, that's why I was like 12:30, I know better than that. I got it. I was gonna say I have a tea time, but that's not till 5 o'clock. Yesterday I was cooking and I had jalapenos and I took them with my thumbs and I touched my eye and I couldn't open my eye for like 10 minutes. Yesterday. I never cook. I was like, oh, I'm gonna cook jalapenos with tacos, and then when I was laying down, I touched my eye. Oh, it was the worst. I couldn't even open my eye. I'm in the shower, just glaring water right down my eye. All right.
Madam Clerk, Your Honor, Brian Gagnick here again. Would it be all right if I check into Judge King's court, or it appears that my client might be a failure to appear. I don't know if the court wishes, I'll ask what the court wishes for me to do.
It's up to you. You want to waive his appearance, we can do that.
I would
And
waive his
that's-
appearance, sir. If I may just provide my phone number to your staff, if he does check in, that way he could contact me. I did hear July 12th as a date. I would be available if that's an option.
Yep. Well, let's just call it.
Calling case number 23576. 23, the people of the state of Michigan versus Gregory Bird. Defendant is charged with count 1. Controlled substance, delivery, manufacturing cocaine, heroin, or another narcotic, 50 to 449 grams. Count 2, controlled substance, delivery, manufacturing cocaine, heroin, or another narcotic less than 50 grams. Habitual offender for notice. This matter is scheduled for a probable cause count.
Good morning, Judge. Alex Wing on behalf of the people, P number P86590.
Brian Gagnick, Your Honor, Neighborhood Defender Service, P64220. May I waive my client's presence for this hearing, please?
Yes, please. You can. Are you available for exam July 12th at 10:45?
I accept 10:45 on the 12th.
All right.
May I leave my phone number with your staff?
Sure.
It is
Go ahead.
313-418-8834. And I'll represent, I have all discovery, so I am prepared to proceed.
All right, thank you.
Thank you, everyone.
All right, take care.
Oh, shit.
Still ain't answering. Where's Mr. Cripps? Mr. Cripps not here.
What side up here? To the bottom there?
Right. Oh, that's Wyatt Harris.
That's why.
Courtroom 233, Judge Johnson.
There you go.
Okay. Is your final?
Thank you very much. Okay, thanks.
Attorney Sadie on our 9:30. It's gonna be 10 minutes away. She's across the street. And Mr. Wyatt Harris didn't answer. Let me try, what's this side? Trying to get Harris, but that's his call there, too. Which side? Yeah. Oh, wait.
That's the one, so I don't know. Oh, you don't think the, well, in. So you want. Yeah, well, I don't either. Oh, no.
Yeah, I don't know, I gave it to you, that's fine. I don't know what I was thinking.
Okay. I do say, though, I don't have 10 4. This is possible. Somebody that just engage that is you know, we should. Chat.
Try Mr. Harris again.
Yeah, he makes it. Katie coming in, social work. No, yeah. You can just yeah. Yeah, he's not. Yeah. And issues that they're bringing. Seems to have like 18 points. Yeah. Last year. Yeah. Year before this. It's all in the criminal. Yeah. And I think that. And then we just. Yeah. This is kid. Yes, yes. I never watched it. So. They could be.
All right, thank you, because your client is, I mean, you just came from there? Oh, well, this client is, but he is,
I just can't.
all right, thank you.
We'll see. I mean, I gotta see it. Because if he doesn't.
Courtroom 233, just downstairs.
Yeah.
Oh, are you on the suicide? What number are you on? Oh, you know what? Okay, you didn't have your last name. Okay.
Yeah.
Yeah, I seen it and I was trying to get, okay. All right, I got Woodside and, Harris. Ready, Harris?
Yes, I'm ready.
Calling case number 2357630, the people of the state of Michigan versus Barry Parker. Defendant is charged with count 1. Home invasion, first degree, habitual offender for notice. This matter is scheduled for a probable cause conference.
Good morning, Judge Alex Warren, on behalf of the people, P number P86590.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Barry Parker, who appears in the Wayne County Jail.
Mr. Parker, can you state your name for the record, please?
Barry Parker.
Thank you.
You're welcome.
Mr. Harris?
Available at 21st.
Your Honor, I've had a conversation with Mr. Parker yesterday, and Mr. Parker wishes to waive his examination if the prosecutor allows.
9 o'clock? Yes. Yes, that works. Yes, thank you.
There's no time for people to figure out.
Any objection to the waiver?
No objection.
Yes, July.
All right.
Oh, I do. Okay.
We got. If you just let your client know, of course. Yes, I will. Thank you.
He's sharing. This is Wyatt. I think you need help. Thank you.
Okay.
All right, Mr. Parker, you understand that you have a statutory right to a preliminary exam where the state must show by probable cause a crime was committed and probable cause you had something to do with committing that crime. You understand that, sir?
Yes, sir.
Anybody promise you anything or threaten you in any way to get you to waive your right to preliminary exam?
No, sir.
You waive your right freely and voluntarily after having opportunity to talk to your attorney about it.
Yes, sir.
And do you have any objection to the court signing your name to the waiver form and initialing off?
Yes, sir.
Okay. Let me add. Do you have an objection to me signing your name to the waiver form so we can complete the waiver?
No, sir.
Okay. Mr. Harris, do you have any objections to the court signing your name to the waiver form?
No, no, Judge.
All right, court will find you freely and voluntarily waive your right to preliminary exam as filed over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 14th at 9 o'clock.
July 14th. Thank you very much, Your Honor.
Yep.
Have a good day.
Thank you. You too. Take care. Mr. Parker, you can tell them that we're done now.
Oh, okay, we're done now?
Yes, sir.
Okay, thank you, sir.
All right, thank you. Take care.
You're welcome.
Ms. Woodside, are you ready? You ready, Ms. Woodside?
I'm sorry, I'm multitasking. Yes, I'm ready.
Okay. Calling case number 23-57592, the people of the state of Michigan versus Canada. Jones, defendant is charged with count 1, robbery armed. This matter is scheduled for a probable cause conference.
Good morning, Judge. I was on behalf of the people, opinion on the
Good afternoon, Your Honor. May it please the Honorable. Good afternoon, Your Honor. May it please the Honorable.
Ms. Woodside, you got, you have
May it please the court, Sharon Fox Woodside, appearing on behalf of Ms. Jones.
Thank you. Ms. Jones.
Kanila Jones.
Thank you. All right, send this matter for exam.
Yes, Judge. Last night I did just get digital, but I wasn't able to look at all of it. It just came in. And so I do want to set it for exam. But the problem is the date. I don't know why I have to look at that.
Well, available.
No, Judge, the connection is so bad. I can't hear you. What day did you say?
July 14th.
No, Judge, I can never do a Friday. I'm on duty in 46. That week is not. That's not a good week at all. Do you have the 17th available?
The 7th.
17. Ms. Woodside, do you have two devices now?
I don't know what's going on.
You gotta turn, you got something else going on there. So you gotta turn off all the electrical devices, please.
So I'm actually standing. I'm in a parking lot. I have another Zoom and another phone going.
Ms. Woodside, that's not you. That's your client.
I'm not buying devices.
Well, that's where the
When she muted the mic, and let's see, now it's good.
Yeah, that's because I just muted.
Do you have the 17th available, Judge?
Yeah.
Hold on, we're looking at it now.
You said the 7th, I didn't give you the 17th.
Or the 19th would be better.
You're stretching it for me.
This is 17. And who again? Oh. Racist.
17th at 9:30.
Yeah, I said it.
Yeah, you can't possibly do the 19th, Judge. I won't ask you for anything else today. I said today.
Okay, yeah, I know. Kitty, can you tell me what we got on 19th?
Because I've got to be downtown. I can be over there by 10.
You said 10 o'clock on the 17th?
The 19th, Judge, the 19th.
Hold on.
Or anytime thereafter. I just have one sentence at 9.
Just look at it, tell me what I got. Okay, thank
You got one exam at 9:30.
All right, 10 o'clock.
Okay, we'll be there.
Oh, I'm sorry, Judge. You don't have any exams on 19th. That was the 20th.
Okay. 10 o'clock, science.
Now, what time are you saying?
10 o'clock.
Okay. Ms. Jones is asking for the ability to go to a doctor appointment. I missed her appointment when she was in custody. And she is on, she did send me verification. I got to forward it to the court.
Okay, Ms. Jones,
I just muted her.
put your system, leave your system on mute because we're getting feedback from your system. Okay, Ms. Woodside, her tether allows her to go to medical appointments.
Okay, she just doesn't want to be in trouble.
Yeah, she just has to provide the information to the tether department in advance.
Okay, thank you, Judge. Ms. Jones, I'll call and explain that to you later, like I told you yesterday. I thought that was the case. Call you later, okay? You can log off. Have a great day, Judge, you and your staff.
All right, you too now, take care.
Ms. Woodside.
19th at 10 o'clock.
Judge, you stretched that.
Yeah, you did. You should. Still within 21 days, so.
He said, oh, okay.
We're doing within 14 days.
Oh, I think that may be, I think we already did his. That may be Mr. Finwall's client. Wayne County Jail, what is your name?
Lorraine Cleveland May.
Yeah. We did his, what did I just do?
7/12/23.
All right, Mr. May, we did yours. Your attorney waived your appearance just for today. Your next court date is July 12th at 10:15 a.m. That's in person.
Okay.
Okay, so did you have a question? Did you hear me say the date? It's an exam for July 12th at 10:15. It's in person.
Okay.
Okay, so you can have the deputy come get you. I'll fax over the paper.
Thank you.
You're welcome.
My question was, is that a personal or cash insured, your judge? I don't know if I show up in person.
I don't think there was a change in the confirmation.
No, change.
It's $50,000 personal with a GPS tether. So you're probably just waiting on your tether.
Okay.
Okay.
Okay. Thank you.
You're welcome.
You all set? What's your name?
Kareem.
Yes. Can I get May's card?
Yeah, you ready? Yeah. Calling case number 23-57503, the people of the state of Michigan versus Brandon Whitehead. Defendant is charged with count 1, identity theft, count 2, financial transaction device possession, count 3, financial transaction device illegal sale use, habitual offender for notice. This matter is scheduled for a exam.
Good morning, Judge Alex Waring on behalf of the people, P number P86590.
Good morning, Judge and staff. Losadi, P74238. I represent Mr. Whitehead, who's present and standing to my right.
Brandon Whitehead. All right, Mr. Whitehead, so you know in the future, I don't do sweats, I don't do sports shirts, I don't do t-shirts, I don't do none of that in my courtroom. Dress for court, do you understand? Do you understand? All right, thank you. All right, you ready to proceed?
The people are unable to proceed as a necessary witness has failed to appear.
Judge, we move for dismissal in this matter. There's an additional issue, though, that has to do with Mr. Whitehead's bond. I'd like to address before we go through with the dismissal.
Okay, what's the issue?
My understanding is that the bond for this case had no tether condition. Mr. Whitehead, before he was released, a tether was placed upon him. We cannot find another case in the system where the tether was supposed to be imposed. He spoke with a member of MDOC. It's their belief that the tether was supposed to be imposed for this case.
He doesn't have a tether. It says 1,000 personal. But already says 1,010%. I don't know why they would put it on that.
I don't know. That's what my client and I understood it the same way. It's supposed to be personal.
So, the thing I say at this point, we'll take a copy of the dismissal and a copy of the ROA over to the Wayne County Sheriff's and they'll remove the tether. It's not some other case. For this case, if it's wrong for this case, they'll remove it. All right?
Okay. Oh, sorry. I can see that right now. Sorry about that.
No, I got it. What's your date of birth, Mr. Whitehead?
10/5/96.
so.
We do
Oh,
our.
we need the,
Thank you.
defendant will be late.
Can I, do you mind if I get 2 copies? of
You want
them?
one too?
Yeah, please.
Yeah. Judge, could I make a change to this dismissal? The complaining witness didn't refuse to prosecute, the complaining witness has failed to appear.
Oh, sure. Well, we don't have that on the record. Doesn't matter if it's in the report, she doesn't want to cooperate. Right now, she just hadn't appeared.
Yeah, I talked to the LC.
Okay.
Do you want us to fill a new one, or do you want us to?
Make a correction.
Okay.
Just initial one.
Second, the boss is back, showing up. The boss is that showing up. That was probably go to class. Right. Yeah, because he's what, that's his, he wants his got to be, so. That's give it to the prosecutor. All right, the guy he's the prosecutor. Yeah,
I need the orders back. If it changed, it has to be on the original order. They, I don't know what they're. Counselor,
We need it.
I need it to be on the original.
Okay.
This is the original. So let's get, let me get you.
So you redid the form, did you redo it?
No, we just.
Just give it back.
We made the correction, it was initially dated.
I understand, but it needs to be on the original.
Yeah, still have it on the original. Okay, right. That's what.
Interesting. That's okay.
Yeah, you know, when you do different. Yeah. Yeah, so that's.
You gotta sweat on fun without it's cool, it is cool in here, so. But yeah, you got it. And it comes all the way down. And it comes all the way down too.
Oh.
Like this is my office.
I don't. You probably got a ton of stuff to fill out.
You could probably do it in your sleep. The amount you see here.
It's the way it's going. You don't need to, no, see.
So the R wave is highlighted?
Yes.
That's for him.
Okay.
Okay. And then this is yours.
Oh, yeah, sure.
I don't know if that's the case. It must not be like that anymore. You know?
Just have a good day.
Take care of yourself.
Can you call, Mr. Cripp's office? Call his cell phone. Call his office, because at least there's somebody in here.
Yeah. This is strange, not like him.
You might think you have anything. Always sometimes, he's more time here than any other courtroom. Usually we still always try to get there on time. Yeah, I'm just tired.
Yeah, usually if he's not logged in, he'll walk in.
It's like, we're busy. I mean, we're looking at car yesterday.
Hi, good morning. This is Katie.
It's gonna cost like
Mr.
$7.
Cripps had a piece of service in front of us. Just wondering.
Not that terrible, that's fine. So we looked at a car.
Yes.
And.
Devontae Davis.
He said, well, can we tell them?
Devontae.
And we'll give a spot. They fix their car, you know.
Thank you.
I said, and then when I told him, I said, can we come back? You know, something.
Was that the last one, was Mr. Cripps?
Y'all don't want to buy that. You better, y'all want to, y'all want to, ain't gonna be take it down 18, I mean, it's 19, that was 17, the tax. You take it down, say. That just hurt me, it really did, I was like, you know, even though I liked the car, she liked it. Now, they did die, who was supposed to sell, try to sell cigarettes. So, he said, well, I know a guy. The pardon, you know, Julie's always charged. Think about that too. But I just see that, you know, this is like the village trying to tell us. We can do this, but if it doesn't work, we have to do another. No, we'll be. A lot of money else, so it's still. So it's something to think about. I'm gonna keep on that. Environment. I like the car.
Who's car? Rachel?
The pre, I'm telling them. You know, I said, something must be. Yeah. They can't acre. Oh, my God. It's done. But yeah, that's I got Rachel too. I said, Rachel, yeah, it's got good attention. Oh, yeah, just. They have to take. That's how you learn. You're not done with me. Oh, mom doesn't go. That's a 10, that's the one you got it. Yeah. Now I'm at 10:30. Yeah. Awesome. So I made it real there. Yeah, yeah. We got 10:30, we got two set at 10:30. Yeah, that's a double, they got a double, yeah. Double.
They're Cody.
Oh, Cody. Last I heard, you know, I heard to get all the cases. That's AG's cases. AG. The last one. AG. Probably casino. Well, yeah. I had a feeling, that's what I told you. Ooh. I'm mad. You say he looked for me. He took it. He passed it. That's why I work. Sure, I'll come right down.
Okay. What time's the next one? 10:30?
10:00.
Oh, that's,
I ain't got prisoners yet. You gotta wait on defendant too.
Nick said a birthday thing. You did. Good job. So that's her birthday. Right. It is today. She won't be here. She's like with the party. What's the party? All right.
That case ain't gonna restrict your phone, is
No, thank
You put
you.
it
I
on.
like it. I already put it on
Check
there.
it out.
Yeah, that's good.
Well, that shows better than the other one.
Yeah, it feels.
And it won't fall into your hand.
Yeah, there's another one. Well, the other one had it too. But this is plastic.
Yeah.
Oh, okay.
Oh, yeah.
This is old cheap $8 off of Amazon. This is the good one. It's a Samsung case.
For the phone that I never got.
Right. Yeah, I got lucky. You never got the phone.
I had that for, after I had that since COVID.
Oh my God. She's so cute. Is it a girl? Yeah. Is it Yorkie? Yeah. Oh my
She got
God.
another dog that's the same one.
She got in the crate.
That's the same one.
Yeah.
She's so cute.
Try to get
She
past
got in the
She
crate.
didn't, no, she didn't. I put
Oh,
her
you
in
put her
there.
in
She
there?
was little and, you know.
Oh, okay.
She got out of the crate.
Hey, but you know.
She didn't get in, but she got out.
She's so cute. Look at that.
But she's 5 now.
Is she?
In the kindergarten. But
I wanted a Yorkie.
so I thought about that picture.
Oh, the one,
That you
mine
showed.
and the Yeah, this is the last one, Mr. Cripps. Good morning, Mr. Cripps.
Good morning. I apologize. I've been in court since 8:30 on hearings.
I was wondering, it wasn't like you.
I had to be in court right at 8:30. I apologize.
Oh. All right, so let me get we call the court reporter back. So we got Mr. Cripps. Yeah, well, he said he's been in court since 8:30. I feel like I had 2 Mondays.
Yeah. I go to my friend.
I'm calling her now.
I don't know.
I know she's like.
You just told me I had. I'm like, 2 minutes, or I'm like, I'm trying to get ready for a year. And then yesterday, she was like.
Oh, she took her phone with her.
Yeah, she gave me her phone number. I'm calling her.
Forwarded to an automated voice.
Oh, come on.
Call her one more time. And then call her. Let me go up here.
She said she was going out to get some heat.
Yeah.
Because it's so cold.
That's what I'm saying. I'm just checking. That's what
I'm sorry, Mr. Chris, we're trying to get the court reporter back.
I want like.
Yeah.
Just gonna be like.
She stepped out for some heat.
I might go come. Y'all want stuff? I mean,
I'm on my way, Katie.
Okay, I'm sorry. All right, thank you. All right.
I can't hear you, but I'm on my way.
Okay, all right.
I'll be doing another one.
Robin.
Right.
Rob dial is not available. Record your message at the tone.
Okay, what's going on?
Are you trying to call the judge?
Yeah. My phone is horrible. Oh, it's not even ringing. All right, Judge, thank you. All right. All right, judge is out of the way, court reporter's on our way.
Yeah.
So we ready? I'm gonna do the PCC first. Alan.
Yeah, the Curtis Mason.
Yeah. Thank you. I was like, oh, I just told her she had some time.
I couldn't hear what you were saying.
Oh.
Did you hear me though?
Yeah, I can hear you.
And then it's so funny, Tyrone downstairs, he just like, I was coming to get you, and he down there running his mouth.
I see.
You know, also I'm running to 2 sheriffs. That is, two more officers.
Right, you know who's gonna run into somebody. So I'm do Mr. Cripps' case first. The PCC.
I'm ready. It's, yeah.
Judges on this one.
Okay, I'm gonna just.
That was so ironic that I gave you the phone number.
Yes. See that? That's why when you said that, I'm thinking like, oh, I was like, yeah. I bet, just in case.
Kitty,
Yes.
is Devonta Davis on Zoom?
No, I don't see her. Oh, no. So I take it you haven't been in contact with her?
With him, he got out on
Oh.
tether, but he's not responding to my phone calls.
I know, I wanna go out there too.
Yeah, I can't. You know what's funny, when you're.
Thanks for calling before you got down here, because when I walk in, everybody be like, looking at me. Right, like we wait, I hear you.
I'm trying to stay true. So,
When's Mr. Dubois, when is his birthday?
Mr. Clark, his birthday is 11/18/1982.
11/18/1982.
11/18/1982.
He's been calling him, he just showed up.
Here, you can give this to whoever, I don't know why it's being dismissed. Did your motion, Alex?
Yeah, both witnesses go.
All right, ready?
Yeah.
All right, here we go.
Okay, court's now back in session.
Ready, Judge?
Yep.
Calling case number 23-57626, the people of the state of Michigan versus Devontae Davis. Defendant is charged with count 1, motor vehicles operating a chop shop. Count 2, stolen property, receiving and concealing motor vehicle. Count 3, stolen property, receiving and concealing motor vehicle. Count 4, stolen property, receiving and concealing motor vehicle. Count 5, stolen property, receiving and concealing motor vehicle. Count 6, stolen property, receiving and concealing $20,000 or more. Habitual offender for notice. This matter is scheduled for a probable cause now.
Good morning, Judge Alex Warning on behalf of the people, P number P86590.
And good morning, Judge David Cripps, P34972, appearing on behalf of Devonta Davis.
All right, waive Mr. Davis' appearance for the purpose of this hearing.
With the court's permission, yes.
All right. Send this matter for exam.
Yes, Your Honor.
Are you available July 14th at 10 o'clock?
Yes, Your Honor. I know I requested discovery. Hopefully it's been sent.
Discovery has been signed.
Thank you.
All right, anything else?
And on behalf of Mr. Davis, and again, I apologize to the court for running late.
Oh, well, okay, thank you.
Thank you, Your Honor.
Calling case number 23-56743, the people of the state of Michigan versus Ulysses Dugar. Defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Habitual offender for notice. Also calling case number 22-56025, the people of the state of Michigan versus Ulysses Dugar. Defendant is charged with count 1, burglar's tools possession. Count 2, larceny from a motor vehicle. These matters are scheduled for exam.
Good morning, Judge Alex Ryan, on behalf of the people, P number P86590.
Good morning, Your Honor. Neighborhood Defender Service by Lauren Anderson, P 85191, on behalf of the Elias DeBar, who is present in court to my right.
Mark, state your name, please.
Julius Dubar.
Thank you. All right, you ready to proceed?
The people are unable to proceed on both cases due to the necessary witnesses failing to appear.
And this time we did this.
Ms. Walker?
Thank you.
Thank you, Judge.
Okay, step this way.
All right, so
You ready, Council?
Court's in session now, ready to go.
Calling case number 2357403, the people of the state of Michigan versus Matt Sean Hardwick. Defendant is charged with count 1, robbery arm, count 2, robbery arm, count 3, count 4, weapons felony firearm. The people of the state of Michigan versus Justin Duncan. Defendant number 2 is charged with count 1 and count 2, robbery arm, count 3 and count 4, weapons felony firearm. This matter is scheduled for exam.
Good morning, Judge Alex Lang, on behalf of the people, P number P86590.
Good morning, Your Honor. May I please wait 1 second?
Oh, yes, Your Honor, Neighborhood Defender Service by Jackie Pilkowitz, PA 1653 on behalf of Nathan Hardwick.
And Matthew Dupree, PA0132, attorney for the second defendant, Justin Duncan. Mr. Duncan, would you state your name, please?
Mr. Duncan. Thank you. All right, state your name for the record, please. State your name. Thank you. All right, you ready to proceed?
Yes. The people are ready to proceed, but there are some matters I think defense counsel wants to bring in.
Your Honor, just with regard to discovery, I did receive additional videos yesterday as well as this morning. I am still missing the video recording of the one of the complaining witnesses' statements. Their written statement is incomplete in the sense that it's a partial statement with some description of what happened. However, some of the responses say on BWC, meaning on body worn camera, which I don't have. So Judge, at this juncture, I just want to place that request on the record. I am prepared to move forward at this time, but it will become, if the case is found over, valuable impeachment evidence. But because my client is in custody, I don't want to adjourn this matter any further.
Judge, I would also be requesting the same discovery. I also want to say, Your Honor, I'm not sure if the people intend to introduce video evidence today, but I would object to that introduction, given that we were only provided the videos less than 24 hours ago. In some cases, it was less than 6 hours ago. I don't think that's appropriate provision of discovery. I'm not asking for dismissal or adjournment. I'm just saying I think they should be limited to using what they had provided to us well in advance of the exam.
I have been in constant communication with the OIC, letting her know that defense counsel Jackie was requesting these videos. As they became available to me to be able to send to defense counsel, I sent them to defense counsel as soon as they were made available. I do not plan to introduce or play videos today as well.
Well, I guess that's a moot point, Judge.
Your Honor, I would.
Counsel, you need to understand that, in terms of these proceedings, the prosecutor's office basically the same body as the Detroit Police Office. Detroit Police Department, excuse me. You're one and the same. So they don't provide the information. I'm going to dismiss. It's just that simple. They're supposed to give it. And you can't wait until they get ready to do it. Point is, my position has always been, once that case is filed and the defendant is in custody or has been charged, then and has counsel, the responsibility to have everything turned over to them. It should be all ready.
Thank you, Judge.
All right.
Your Honor, I would move for a mutual incapacitation order, including the officer in charge if she plans to testify at today's hearing.
I do plan on calling the officer in charge to testify.
All right. Any witnesses testifying today at trial or any time in the future must be in the courtroom or be denied that future testimony. That includes Zoom and YouTube. The officer in charge, you have to step out, please. Oh. Oh, so.
No worries, we'll do it the long way.
Vice President?
The people call, Officer Rhonda White.
Officer White. Approach.
Yeah, please.
I will be responding all.
Speak to you. Yes.
No, you can't. How you get past this?
It's a written.
I don't care. It's still hearsay. Is it one of these two? Are they juveniles?
No.
Then how can you get that statement in?
It was Miranda.
I don't care. They have constitutional rights. We have certain procedures that we have to operate on, rules of evidence, statutes, everything else. How can you get in? Period. What exception to the hearsay rule can you give me?
Can you give me a moment?
We also just got that yesterday, like this morning.
Oh, let's wait.
So we'll wait, yeah. So I just put it, yeah, I use. Child support. Uh-huh. Right. Oh, we don't have it. We don't have it.
That's why.
I don't know that.
Judge Manfro.
Yeah.
We're gonna ask,
Well,
I'm gonna ask for dismissal for insufficient evidence and going to reissue and provide defense counsel that video before the next court date.
Judge, if I may, what problem does that solve? It's still hearsay. Or it's gonna be circular. There's also ID. And there's the
One of my
officers. No, they can't.
Well, I talked to one once also. If it's being dismissed and reissued, then that's a problem to be handled once it's reissued. For today, all that matters is the dismissal.
I understand that
I know.
the position, yeah.
Can
But you know, a whole lot I can do about
can I speak with the victims and see how they want to proceed? Because the one victim who I'm speaking with says he's going to identify one of the defendants, and if they're comfortable with that.
I mean, they.
I mean,
You know, we didn't identify.
I'm going to go speak with my victims.
Been a whole different story at trial.
Dismiss for insufficient.
The ink is dry.
Excuse me.
That's what we're doing.
We're going to dismiss for insufficient evidence.
Judge Jackson wanted to know if you had time to do what they said before.
You say you had.
You decide
Yeah.
to circle those. I don't. Like,
Oh, yeah. Judge, may I bring my OIC for this?
yeah.
Someone use it.
Back on the record on 2357403, which is people state of Michigan versus Nashawn Hardwick and Justin Duncan. Parents of one more time.
Good morning, Judge Alex Wayman, on behalf of the people, P number P86590.
And good morning, Judge, Neighborhood Defender Service by Jackie Tilkowitz, PA 1653 on behalf of Nate Sean Hardrick.
And good morning, Your Honor. May it please the court, Matthew Dupree, P80132, attorney for the other defendant. Mr. Duncan, would you state your name, please?
Mr. Hardrick, will you state your name?
Make sure.
Thank you.
The people asked to be dismissed for insufficient evidence.
We would join in the motion, Your Honor.
The same, Judge.
Both matters are dismissed without prejudice.
Thank you, Judge.
Thank you, Judge.
Thank you.
Judge, for The issue of the defendants getting out.
Nothing to do with that.
Okay. I'll let the OSC do it.
Well, I send that knows how to do her job. I mean, she can have them arrested now. They can hold 3 days and recharge her.
Okay. Deputy Sway, you again?
You're getting out today. What are you saying? So, yeah, Monday. Probably on Monday.
Should I grab Mr.
Yes,
Blue?
please.
Oh, his fault.
Oh, that.
Y'all have a very nice day.
You want the paperwork?
Oh, I would like to do. That's a good idea.
And then you move in a group.
So. Oh, I'll try to catch Jack.
Where's your client, Mr. Reed?
Yes, Mr. Blue.
Oh, that's your client?
No, I got another case from.
Huh?
Yes. I'll get the prosecutor.
They brought it down. Where's your client?
We're ready, he's right here. We're ready.
Oh.
I'll bring him in. This is Blue, this is Mr. Blue.
What's on the next? I talked to the officer. Assistance or
Sorry, which case? Blue? Wait, I asked about, the. Okay.
The interview. Yes, what the interview?
Oh, with my client.
Yes. So it's past the 30 days, he doesn't talk to the officer.
Okay, because I think it's a 90-day policy regardless. I can make my argument. I'm also missing, there's only body camera footage from after the arrest.
Are we ready on Blue?
It's on the record.
Alex, are you ready? I'm Blue.
I gotta see my witnesses. Oh, you signed it.
Yeah. That's one ROA. Jackie, what's your P number again?
81653.
Ready on blue?
Yeah.
Okay, I guess.
We're ready.
Calling case number 2357245, the people of the state of Michigan versus Charles Blue. Defendant is charged with count 1, weapons carrying concealed. This matter is scheduled for exam.
Good morning, Judge. Alex Wing on behalf of the people, appealing on P86590.
And good morning, Judge. Neighborhood Defender Service by Jackie Pilkowitz, P81653, on behalf of Mr. Charles Blue, who stands to my right. Mr. Blue, state your name for the judge, please.
Thank you. All right, we ready to proceed?
The people,
The defense is moving for a dismissal in this case for failure to provide discovery. First and foremost, Judge, I requested the recording of my client's interrogation. I was just informed that recording has been auto-deleted by because it's lapsed over 30 days. Judge, that's problematic for a few reasons. First and foremost, I believe the Detroit Police Department policy is to keep them for 90 days. So this 30-day figure, I don't even know where it's coming from. More importantly, Your Honor, it's a violation of a statute which requires the Detroit Police Department to preserve any video recording evidence. Of course, it is directly relevant to the offense. It incriminates my client. It's his recorded statement. Pretty much a fundamental building block of the prosecution's case. So even if they don't intend to use it today, Judge, I do believe that there is no sense in finding this case over if that in fact doesn't exist at this juncture. Additionally, Judge, I also am missing the body-worn camera footage from the 2 arresting officers. All I have by way of footage is recordings that start after my client is arrested. I don't have, this is a CCW charge, I don't have the body camera footage of any of their initial observations of their chase of my client. They're claiming that they observed a handgun somewhere on his person. I don't have the recovery of the firearm recording. I have pretty much nothing that will assist me with adequately confronting and cross-examining the witnesses against him. I'm asking for a dismissal under the court rules 6.201J, which allows for a dismissal for a discovery violation when the court deems it just under the circumstances. I'm submitting that this is the circumstance where it is just, where I can't effectively advocate for my client cross-examining witnesses today or otherwise, Judge. So with that, Your Honor, we're asking for a dismissal.
People wish to be heard.
I have brought in my OICUs in here and speaking to the interrogation of the video, he has let me know that the 30 days is past. The video, to his knowledge, no longer exists. Relating to discovery, what the defense counsel is stating, I've not received, to my knowledge, a discovery order. And I think defense counsel can contest that she has not sent a discovery order for this case. And going to the issue of the body-worn camera and the digital evidence that she is requesting.
Okay, that you kind of skipped over the fact. Did you provide the discovery?
I provided discovery of digital evidence that was uploaded and given to me.
Okay, but you were informed that that was not complete.
Defense counsel did email me, and she only emailed me in regard to an interrogation video that was 30 days out of the time that the OIC said no longer exists. I addressed that. I did send her not an email addressing that, but I did send an email addressing the fact that she asked for Officer Mobson's body-worn camera, the videos that she's speaking of prior, during, and all those other videos. I do not have an email from her describing that.
And that is accurate, Your Honor, because I received Officer Mobson's body camera footage yesterday. So I hadn't had time to even review and reply to whether or not it was complete. So arguably I could have let you know that Malik's was incomplete. I was hoping that Mobson, it would have been complete. Neither video is complete. Neither video captures a recovery of a firearm, a stop of my client, any of that. It's after the arrest. So I did not know. Did I notify counsel yesterday after receiving one of the videos? No, I did not. the OIC is here, if it exists, my guess is it doesn't exist, which is a problem, and that would be just a guess, but we could ask the OIC, because if that is going to be outcome determinative for the court's decision, it may be helpful.
The OIC,
I mean, I can go back and review it, that's.
you could go, so that's.
What about the
I can't answer that
videos of
question.
the arrest, the videos of what happened before the arrest? I mean, all that, it should be on video, on body worn camera. So all that should be provided. Does it exist? What's the one, they stand up, state your name first, please.
My name is Police Officer Christopher McLaughlin, badge 3295.
Have you seen the videos?
I have seen the videos, and the body worn camera is activated as they're getting out of the car. They had to reverse the vehicle, and I uploaded it to evidence.com. I mean,
So they exist.
yeah.
Judge, if I may, I think we're talking about the same video. That doesn't start, within 30 seconds, he's arrested and on the ground, is that correct?
Correct.
Okay, so we don't have, there is no video recording of what happened prior to the arrest.
Okay, that one I would have to review, see if there is any video. If that video does exist or does not exist, I don't know.
All right, this is what I'm gonna do. I'm gonna put this over, I'm not dismissing it. I'm gonna put it over. Now, the video regarding interrogation. That doesn't exist anymore.
That does, to your knowledge, doesn't exist?
So as far as, I just got the request yesterday for the interrogation video. As far as if this is just an access control and I only have up to 30 days and I need to go make a request to, that it does exist past 90 days or prior to 90 days, that's fine. I can go above my head and go to supervision and get a request for those videos. But as far as my access, I only have 30 days from that interrogation of that report.
Then why don't you have it?
Because I was just given the request for the interrogation video.
This is part. Interrogation is part of your case, and you're the OIC. You're the one that collects all the evidence.
Yes,
right? And that would be part of the evidence, would it not?
Correct.
You wouldn't collect it, or you just didn't in this case.
I didn't in this case, no, sir.
All right, that's what I'm gonna do. I'm gonna put it over. Do discovery order now. I need to know if it exists, all of it. And I need to hand it over if they do. And if for some reason they don't, especially the interrogation video, I need your motion in writing, I need your response in writing. Oh, we're gonna put this out, so we have enough time to handle that.
Judge, I'm out of the country from the 20th through the 30th. If we could possibly do it the 17th, 18th, or 19th, and perhaps a motion deadline or, a prosecution provide discovery deadline by a week from today, or I'll leave that in the court's discretion, but my request would be for the week of the 17th if possible.
No discovery provided by the 13th. Wants just a motion submitted by the 14th. I want the answer by the 17th. We're gonna have an exam on the 18th. And we do this at 9 o'clock. Can you let? Katie, well, let me make sure. July 18th.
No exams on that day.
Do 9 o'clock?
Yes, Judge.
July 18th. 9 o'clock.
Your Honor, would the court like me to prepare a written discovery order or what the state? Yes.
You want to actually just do this.
Okay.
Scales right now. Have it served right now.
For what?
For discovery.
No.
Oh, you can get the discovery order now.
Okay.
I'm gonna fill it out, I'm gonna sign it. Take it in there now.
Are we up for the record, Judge? Are we on the record or off the record?
We're still on the
I think Mr. Reed.
Well, Mr. Reed.
Well, we just lost, where did the thing go?
Who?
Oh, apologize. I think he left.
Oh, you should have not took a stand.
Thank you.
He's not out there now.
Oh, the defense?
Yeah.
What? Yellow.
Oh, no, blue.
What, the defendant? Blue.
Yeah.
Okay.
Step up here, next to your counsel, please. Yeah, let's just get it. What's the issue?
Oh, she's filling out the discovery. I didn't know if you wanted us.
Yeah, I'm gonna sign the discovery. Also, what happened today. And,
Yeah. Oh, can I approach the bench real quick?
I mean, also, would you regard this case?
Yes.
Then, I mean, both of you.
So. No, I just wanted to check clear on this. Defense counsel is bringing the motion, and I respond to the motion.
First,
They're ready on both of the
Then
cases.
give
They're
me the
ready
answer
on
by
our
Thursday.
11:15.
I will file.
And
Depending on whatever answer you get,
Okay.
you will respond, we will be here
the
to
both
argue and vote the
holds, I do believe,
But I'll be planning to
Tony
dismiss,
Yes.
depending on
Yeah,
whether.
but he finds, and I'll let you know
Yes.
what he finds.
Yeah, by the
He
13th.
has a
And then
witness.
the other motion, if he wants to, then I respond to that. And send it to the,
Yeah.
okay.
All right. More time, 7 days from discovery, you know, 7 days.
Yeah.
I'm asking, does he have everything he needs?
Key date 13th, 14th, you want that back by?
I'm gonna be filing.
He has to file it by the 14th, yours is the 17th.
Oh, thank you, that's right. Thank you, that was my.
Back on the 8th.
Okay, thank you. I didn't want to do that.
Good.
All right, thank you, Judge.
All right.
Yeah.
Or neither.
Yeah. I don't think before.
Yeah. I don't know if you want.
Is there another?
Yeah. We can ask the clerk. Huh?
That concludes the hearing then.
Okay.
So, okay, have the other one.
Discovery order?
You provide it to the officer.
We gotta give it to the officer.
Oh,
I guess.
Oh, you get that to.
Ms. Blue, you can wear them up.
yeah. Did you make a copy of the discovery order?
I need 2 copies. one.
And then, yeah, so 3 total copies, yeah. Oh, sorry. Oh, it can be those, that's fine. Yeah, I guess we just need one then, for the OIC. Perfect.
These can be.
Your copy.
Oh, man.
These are the 2 things you request. So which one do you want to do first?
Oh, and
I mean, usually.
I think I have those. Yeah.
Okay.
So. This is for.
Anybody. Prior.
Thank you.
And then the recording. Yeah. Yeah.
Okay. Something by 13. Left one.
We'll just email you the motion, is that fine? That's fine, just email it to you.
Yeah.
Okay, right.
No, she's touching those.
Have a good weekend, everyone.
All right, you
Take care
too,
now.
thank you.
Step right up.
What do you think you get out early?
I'm not doing it.
I was just messing with
Yeah,
you.
Yes, you're welcome.
All right, thanks.
Parties ready on Antonio Miller. Calling case number 2357006, the people of the state of Michigan versus Antonio Miller. Defendant is charged with count 1, controlled substance possession, count 2, weapons, felony, firearm. Count 3, controlled substances, possession of cocaine, heroin, or another narcotic less than 25 grams. Count 4, weapons, felony, firearm. Count 5, weapons carrying concealed. This matter is scheduled for exam.
Good morning, Your Honor. This is Buster Boyd, moving for the people.
Good morning, Your Honor. May I please put Daniel Reed, number 30965, on behalf of Mr. Miller, state your name for the record.
Daniel Miller.
Thank you. Defense ready to proceed, Your Honor.
So are the people. We call Officer Schultz.
I don't believe there's any need for sequestration. I think the prosecution will do that. Yes.
This is Brenda Johnson sitting to my left, but she will not be testifying.
No, that's.
Oh, Sean Schultz, SHAWN, CHULTZ.
Thank you. Step up here. Raise your right hand. Swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Pull the door towards you.
All right, good morning, sir. Your name for the record, please.
Sean Schultz.
And you work where?
Detroit Police Department.
Okay, so I want to take you back to the date of May 12, 2023, the location of around number 1 East McNichols. At about 2 o'clock in the morning or so. Were you at that location at that date and time?
Yes, sir.
All right. And is that in the city of Detroit County, Wayne?
Yes, sir.
All right. What is this known as other than that address? Is it a storehouse or what?
It's a gas station.
Okay. And you arrived at that location in a scout car?
Yes, sir.
Plain marked or otherwise?
Fully marked.
All right. How about yourself? How were you dressed?
Fully marked you.
Indicating you're a police officer in the front or back?
Yes, sir.
All right. And you had other partners with you at the time?
Yes, sir.
All right. Who was there?
My partner was Officer Ryan Keaton.
All right. Other officers involved though?
Were Officer Edwards, Officer Swart, and Sergeant Andre Brooks.
Okay. All right. Now, you went to this location for what reason, sir?
I was there to assist.
To assist?
Yes, sir.
Okay. Well, were you given any information as to what to assist for?
Yes, sir. Crime intel, that is a green light.
All hearsay. If you got information, what do you do based on that information?
Right. Okay.
So,
my question was, did you get information? Yes or no?
Yes, sir.
Okay. And the information that you were given, did you act on that?
Yes, sir.
All right. And what did you do then when you acted on it?
I was given.
Not what you were given. What did you
Okay.
do?
I went into the gas station, searched the area that a suspect, an armed suspect, was supposedly had walked through.
There's no foundation for
Okay,
that.
you went to the gas station. I want to know what information you had and what information you were given. Just, you went to the gas station and what did you do?
I went to the gas station, I searched the gas station and found the gun.
Okay. And with regard to the information you were given, was a description of an individual or anything else given? Yes or no?
Yes, sir.
All right. And when you got to that location, was there also a description of a location of something that you recovered?
Objection, Your Honor, as he's leading this witness. He has to say what he did. He has to testify, not the prosecution.
Well, Judge,
Well, he did testify that he said he went to the gas station and he found the gun.
Okay.
That's
He
what
did say that.
He did say
Yes,
that.
he did.
Yes. And that's it. In terms
That's all
of.
he said so far.
All right, that's fine.
Okay, and with regards to that, was information given you as to that weapon that you found?
I was given information in the area where the weapon might be.
Okay, and you went to that area?
Yes, sir.
What area was that?
I found the pistol underneath, I believe, a coffee maker, some kind of kitchen appliance near the coffee maker and microwaves inside the gas station.
Okay, And when you went in there to recover it, did you notice if there was anybody else around that area? When you
There was
recovered the
Sergeant
weapon?
Burks in there, Officer Edwards, and then there was a couple patrons in and out, but they stayed by the front counter, by the checkout counter.
Okay, were they anywhere near that location where you indicated a kitchen type situation?
No, sir.
All right. And now, when you located that weapon, can you tell the court what it was?
It was a black Taurus pistol.
Okay. And you know whether it was loaded or not?
I'd have to look at my report. I know it was loaded, I don't know if there was a round in the chamber or not,
All right.
so
Okay,
that's
all
all
right.
I need cleared up.
So what did you do with this now?
I recovered it and placed it on evidence.
Okay. Did you speak to any of the other officers at all as to what your findings were?
I informed them that I found a gun.
Okay. Did you recover anything else, sir?
No, sir.
All right. And, did you observe any other recoveries at that location by the other officers, sir?
I don't think so, no.
Okay. And with regards, a yes or no question, with regards to the information you received upon going there and recovering that weapon, was the location of an individual near you?
Yes, sir.
Was it that same location where you recovered the weapon?
Yes, sir.
All right, thank you, nothing further.
May I cross, Sean?
Yes.
Officer Schultz, it is officer, right?
Sergeant.
Sergeant, I'm sorry, sir. Sergeant, you've indicated that you went to that location about 2 o'clock in the morning, is that right?
Yes, sir.
All right, and you went inside that location, is that right?
Yes, sir.
And you found a gun somewhere inside that location, is that correct?
Yes, sir.
And there were other individuals inside that location, is that correct?
Yes, sir.
There were police officers, how many of those?
2.
And how many civilians were there?
I'm not sure.
But was it more than one?
Including like the manager and
Whatever.
the clerk, yes.
Okay.
More than one.
There was more than one inside that location, is that right?
Yes, sir.
You did not find Mr. Miller in that location, is that correct, sir?
No, sir.
And you never saw him in possession of your weapon or anything like that, is that true, sir?
No.
All right, thank you, sir, nothing further.
Is there anyone here in the courtroom that you saw at that location?
I saw Mr. Miller detained out front.
Okay, and where is he in the courtroom today and what's he wearing?
He's wearing a blue button-up shirt, sitting at that table right there.
The defense table?
Yes, sir.
Thereby identify Mr. Antonio, Judge, for the record. Thank you. Nothing further.
Not to delay the matter, but again, you did not find Mr. Miller inside of that store, did you, sir?
No, sir, he was in the parking lot.
He was outside in the parking lot, is that right?
Yes, sir.
All right, thank you, sir.
Thank you.
Thank you.
Officer Schwartz.
I'll grab.
Your name.
Colin Swart. COLINSWART. Yes, ma'am.
No, just step around this way. Right. Raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Right, close the door towards you.
Yes, sir.
Ready?
Thank you. Good morning, sir. Your name for the record, please?
Colin Swart,
Okay, and where do you work?
for Detroit Police Department.
All right. Now, sir, I want to take you back to date of May 12, 2023, the location of 1 East McNichols. And on that, at that location and on that date, did you have occasion to go there?
Say that one more
Did you
time.
have occasion to go to that location on that date that, May the 12th?
Yes, sir.
Okay, is that, what is that, location?
It's a, gas station.
Okay. And, with regards to that location, sir, were you working with other officers?
Yes, my partner, P.O. Edwards, that's who I was in the car with.
Okay. And you arrived in a scout car,
Yes, sir.
marked plane or otherwise?
Semi-marked patrol vehicle.
Okay. And how were you dressed, sir?
Class C uniform, so, basically police pants. I have a vest on, has police on it.
Okay. And why did you go to that location, sir?
With the location, my supervisor, P.O. Brooks, or Sergeant Brooks, basically said,
Objection, you said you received information.
Received it from,
I received information from my supervisor that he received
No,
information.
not, you can't say what he said.
Okay.
You just said you received information, and based on that information, you did.
Okay, I received information that there's an armed person at one East McNichols.
Let me break it down. All right, you received information about that location.
Yes,
All right, and the information that you received, can you tell the court what then you did?
we drove to one East McNichols.
Okay, and was there any information given about a specific individual or anything else? This is
Yes.
yes or no? Okay, all right,
Sorry.
now, when you got to that location, did you see anybody with any description that was given you?
Yes,
Okay, and the individual that you see, male or female?
it's a male.
All right, and anybody in this courtroom here today as to met that description and that was there at that location?
Yes,
Okay, can you tell us where that person is in the courtroom today, what they're wearing?
yes, he's wearing a blue button-up shirt.
Whereabouts in the courtroom, sir?
Sorry,
Whereabouts in the courtroom?
to my left, right here.
Would that be at the defense counsel table?
Yes,
All right, for the record, identifying Mr. Antonio Miller.
Not gonna solve the claim.
All right, thank you. And when you saw Mr. Miller, what happened? What did you do? Where'd you see him?
walked into the gas station and saw him at the front counter,
Okay,
matching the description.
okay, and what happens
But,
now?
hold on, let me back. You saw him at, what? You said he was walking to the gas station?
No, I walked into the gas station.
Oh, you walked
Yes,
into the
sir.
gas station?
And then, saw him at the front counter where you would check out at, matching the description.
Okay, so what did you do at that point?
I observed him and I just, off my observations, I couldn't tell if he was armed at that time. Didn't look like he had, the handgun on him at that time.
So what did you do?
We had him come outside, we had him come outside, basically stand in front of, this vehicle, until we had more units come to help assist locate the firearm. I was
Okay,
seen,
all right, and then what else, what further did you do?
I stood by with him while, my partner Gil Edwards and, Sergeant Schultz went inside the gas station to locate the firearm.
Did you see a firearm come out with these, officers? In their
Yes.
hands? All right,
Yes.
all right, and, did you see what they did with the firearm?
I'm unsure, I didn't take possession of the firearm, so.
Okay, all right, what happens now? What did you see?
After, he was gonna be arrested for CCW, so he was placed on arrest for CCW. Me and my partner did a search of his person. And that's where I, located the, tablets, the 4 XC tablets that were on his person, and then he alerted me that he dropped one.
Objection, Your Honor. Anything the other person may have said.
Judge, let me clarify, who said something about something?
The defendant said, I dropped one.
Okay, at that time, did you ask him whether he dropped one, or did he voluntarily give it?
He voluntarily said to drop one.
Okay, and did you see something on the ground?
Yes, it matched the same 4 pills I got off him, and I put them all together.
Okay, and, it landed where, how close to this gentleman?
Right next to him, right behind him.
Okay, so now, you indicated how many other pills aside from the one on the ground?
She had 4 in his person, and then the one that fell on the ground, so it'd be 5 total.
Were they packaged in any way?
The four were together, and the one was loose.
Okay, so together how?
Yeah, in a plastic baggie.
Okay, and with those items, now it's 5 pills total, is that what you're telling me,
Mhm.
Laura? Is that yes?
Yes.
All right, and with that, what did you do with them?
We'll place them on evidence. Recovered them. Then place on evidence.
Okay, and placing them on evidence, how do you do that, sir?
You have to get the lock seal number, you have to contact narcotics. They receive that number, and after you go back to PPU, which is at the 11th precinct, and you turn over the narcotics to PPU.
Okay, all right, now, was a lock seal number given you?
Yes.
Do you remember what that was?
It's a long number, so it'd be hard to.
So the answer is what, yes or no?
It's in my report though.
All right, do you need to use that to refresh your recollection?
Yes.
Yeah, approach, Judge?
Yes.
That's fine. Good. I'm handing you 2 pieces of 8.5 by 11 with writing text on it. Do you recognize that?
Yes.
What is that, sir?
It's my report.
Okay. Look at that, if it refreshes your
And
recollection.
it does have the lock seal number, which is gonna be Nora 005-749-155, which I was provided by narcotics when I contacted them.
Okay. And now, what else did you do with this this gentleman, this matter?
Well, after, he was placed on arrest with CCW, and then once we recovered the narcotics, it's BCSA as well, we transported him to the Detroit Detention Center for processing.
Okay. Was there anything else recovered from this gentleman when you searched him and recovered the suspected narcotics as you did?
Personally for me, I didn't recover anything else from him.
Okay.
But
was there another officer standing there?
My partner, P.O. Edwards.
Okay.
Helped search his person.
All right. Were you standing there with him when he was searching?
Yes.
All right. And did you see anything being recovered?
Yes, I saw several items taken from his person and put on the hood of the vehicle that we're in front of.
Can you describe what those were?
Some of it looked to be crack cocaine.
Okay.
Suspected crack cocaine at that time.
Do you remember how they were packaged?
I believe one bag was a clear knotted bag.
Objection to what he believes. If he knows, he knows.
I know one bag was a clear knotted bag.
All right. Were you able to describe a number of or what was inside it, how it was formed?
One bag had.
Were you looking at your report?
Yeah.
You can't do that. Put your report down.
Sorry. Are you able to tell us what it was?
At that time, no.
Okay. Would looking at your report refresh your recollection, sir?
It would.
All right. They do so refresh if you need to.
What was the question?
The question was like, how it was formed or what was inside it. That plastic bag that he indicated he saw. Does that refresh your recollection, sir?
Yes, sir.
All right. Can you tell us what it was?
I can for sure say one knotted bag with crack cocaine in suspected crack cocaine in rock form.
Okay. All right. And did you see What happened with that suspected narcotic?
It was recovered by my partner.
Okay, and was there a lock still given?
It's under the same lock, sir.
The one that you cited here today?
Yes, sir.
All right. And anything else recovered from this gentleman?
Not for me, no, sir.
Okay. You see anything else being recovered?
I believe I know there were several other items, but it was recovered by my partner.
All right. Okay, now, this gentleman was arrested for CCW. Were you able to see why he was arrested for CCW?
See why?
Yes, sir. Were you there at the time?
Yes, I was there at the time.
Thank you. That's pretty good.
Also, yeah, very briefly. So you've indicated that you went to the location and you saw Mr. Miller there. Is that correct, sir?
Yes, sir.
All right. You never saw him in possession of any weapons or anything like that. Is that correct, sir?
Yes, sir.
And you never saw him in possession of any ammunition or anything like that. Is that correct, sir?
Yes, sir.
No holsters or anything associated with the gun. Isn't that true, sir?
Yes, sir.
All right. Your testimony is just basically that you said you recovered some suspected narcotics from it. Is that correct, sir?
Yes, sir.
All right. And I think your testimony was a small amount. Is that correct, sir?
Say it again, sir.
It was a small amount
Amount of what?
of whatever it was. Cocaine, you said, what did you say it was? Suspected. I'm saying that's.
I'm not sure what a small amount is.
So what you saw a baggie or something? Is that what you're saying?
Yes, sir.
Okay. And in the baggie, you saw something, some powdery substance. Is that correct, sir?
In which bag?
Whatever one you saw. I wasn't there.
Sir, I recovered a bag with pressed pills in it.
With
And
pressed pills.
Sorry?
You said you recovered a bag with pressed pills in it. Is that what you're saying?
Yes, sir.
Okay. And you didn't know what it was at that time. Is that correct?
Through my experience, I can have an idea of what it could possibly be.
Well, not an idea. I mean, it wasn't like you analyzed it or anything. Is that correct, sir?
It was tested.
Did you test it?
No, sir.
Okay. All right. So you don't know what it was in terms of that. You didn't check it or test it or anything. Is that right?
At that time, I couldn't tell for sure what exactly compounds were. Yes, sir.
Okay. Thank you.
Yes, sir.
Nothing, Brad.
And with regards to the gentleman that you indicated here in court today is Mr. Miller, you did indicate you saw him in that store.
Yes, sir.
All right. At the time you saw him, did you see anything on his person?
No, sir.
Yeah, approach it.
I'm going to object.
For what reason?
I'm sorry. He has some photographs he wanted to present to him, but I was going to object to that because he's not the scrivener of that. He's not the one that took the photograph or anything. He testified he saw him inside the store, but I guess with the police officers. That's all I saw.
At the counter, Judge.
Yeah, that's all on the counter, I got that.
Right. Which is what this is.
Good approach. Good approach.
Thank you. All right, sir, I'm handing you two 8.5 by 11 photos, black and white it is. You recognize those?
Yes, sir.
All right. Is that accurate depiction about the individual that you saw at the store?
Yes, sir.
Okay. Is that the same individual here in court today?
Yes, sir.
All right. And with regards to that, the two photographs, where is the first photograph, the one that takes the full page up? Where's that person at?
This person?
That's the one I'm speaking of.
Yes, this person. This is exactly where the person was standing when I walked in the door.
Okay. All right. And Does the second photograph, the smaller picture, is that a same depiction of the same picture, but in a concentrated, I guess, form?
Appears to be the same clothing.
Okay. Does that show anything?
I don't think I'll describe what it shows. He can identify what it is, what the picture is. I'll look at it, describe what it
Okay,
shows.
very good. All right, thank you. All right. May I publish that to the court judge?
No, Jason.
All right, thank you.
No further questions, thank you.
Oh,
Yes. Sir, these pictures that were handed you, you saw these pictures later on, is that correct, sir?
Say it again, sir?
When did you see these pictures of this, the ones that you saw before today? Did you see them before today?
Just now.
Just now is the first
Just
time you
now.
ever saw them?
Yes.
Now, you indicated at some point in time you walked in the store. Did you see Mr. Miller in the store?
Yes, sir. That's when I first saw him, was using the store.
Okay, and you said you stand in the counter, is that correct, sir?
Yes, sir.
And you didn't see him in possession of any gun or anything, did you, sir?
I didn't, I observed him, I looked at him, looked at his clothing for any ballies or any type of L-shaped objects, and I could not observe any at that time.
Okay, and you didn't arrest him or anything at that time, is that correct, sir?
He was not under arrest at that time.
Okay, and then he walked out of the store at some point, is that correct, sir?
We walked out together.
You walked out together, okay. And you saw him at the counter, not at the coffee machine or anything like that, is that correct, sir?
I saw him at the front counter ready to check out.
Okay, thank you, that's nothing further, this witness.
Nothing further this time.
I do. You saw him at the counter and you walked out together.
Yes, sir.
Okay. What happened then?
We walked out together. He was being detained due to him matching the description.
For the information you had, you detained him.
Yes.
And so at that point, was he searched?
A search was not done until he was arrested for after they located the firearm inside the store.
Okay, but from the time that he walked out, did he ever return into the store?
When he walked out, did he return in the store?
Right.
No. Once he was outside.
He was with the police officer the entire time?
Yes, he was with me. Yes.
Okay, and then after the other officers came outside with the weapon you saw, then he was arrested and searched.
Yes, sir.
Right?
Yes, sir.
And the only thing found on him was the alleged drugs, is that correct?
Yes, sir.
Okay. Any questions based on my questions?
If I may, Judge, with regards to timing, when you saw this gentleman in the store, he was then asked to come out of the store. How much time passed from when you saw him to when he was asked to come out? If you know.
Well, when I made the location, he wasn't in the store without an officer until we came back outside. So the amount of time we were in the store was less than 5 minutes. And we went outside, waited for other officers to get there, so we could stand by with him while we looked for this weapon.
Okay, so for clarification purposes, when you saw him inside the store, there were no other officers, just yourself? I don't know if I'm
It was
understanding.
me, my partner, P.O. Edwards.
Okay, and did the both of you officers come out of the store with this gentleman?
I was for sure with the gentleman outside, and we'd like to get more than one person standing by with the detainee at the time. So we had another car come.
Okay. Okay, thank you. Nothing further.
Nothing right there.
Thank you. Step down.
Thank you.
Thank you. There's no further witnesses. Thank you.
No presentation by the picture.
Judge, at this time, we have no further witnesses. We would then, make our motion by going to count 1 through 5. And with regards to arguments, Judge, the, testimony here today indicates basically a circumstantial situation wherein the gun was located inside this store where this gentleman was, and information was given as to a description, location, gender, etc.
All that's hearsay. I don't care about what was given. That's all
That's what they
hearsay.
saw.
None of that, no. All that is hearsay.
All right.
Officer, the only thing that information does is give that officer reasonable suspicion to act. That's
Okay.
all it does.
All right.
So it gave him reasonable suspicion to detain this gentleman. It gave him reasonable suspicion to look for something. And that's what he did.
Okay.
So you want to talk about circumstance? You're missing a whole bunch of dots here.
Well, Judge, if I could just finish up, I'll try to connect the dots the best I can with what we have the evidence.
Well, let me put forth a couple things I don't think you connect the dots on.
All right.
One is the drugs. Because I got nothing to say to the drugs. Nothing. Also said they're suspected drugs. That's the only thing he can testify to. I got no
You're right, Judge.
lab reports, nothing to say to drugs. So
You're right.
that's out the door. So there's no circumstances, no nothing as to that. You know, the other issue, as you know, let me just put it out there, and then you could then I'm allowing you to finish your argument.
Right.
That I would have.
Okay.
Is that defendant was in the store. He was at the front window of the store. When the officer saw him, officer went and got him, took him outside. Now, in the window, there is a close-up picture of something in his pocket. I'm not sure what that is. But he was basically in police custody from that point on. So if that was something, then I wouldn't know about it because they would have testified because they searched him. And he never left their presence. The problem I have is they don't have anybody. You haven't had anybody to come to say that he was even in the area where that gun was found. Nobody. I got nothing to say he was over there. I got nothing to say that that someone puts a gun in his hand. I got nobody definitely to say that he was hiding the gun, that he brought it in there for the CCW charge, or any of it. Now, if you can connect those dots, I'm buying it over.
I understand, Judge. What I was getting at initially, and first I have to make mention that if I open up the proofs, Mr. Reed does have a copy. I gave him prior to court here, a copy of my MSP final lab. And I don't have it here in front of me, and that's probably why it slipped my mind to present it to the court. Okay. So that would be one motion we would do at this point in time, but let me address the other one first, okay? With regards to this weapon, there was information given. They did find this individual here. We don't have this witness testify, any witness testified that this person was at the coffee counter. I guess that's what it was at the time. However, we do have testimony that no one else was there. There were other patrons, but they
No, there were other patrons there in the gas station.
Pardon me, Judge?
There were other patrons in the gas station. That's what Officer, the first one, you know what name, right? Officer Schultz testified.
Yes, but he did not testify that there were any. He said there were no other patrons. They were by another section of the store, not by that counter, by the coffee counter. He did testify to that. So with that is what I'm trying to get at with the circumstantial evidence part of it, along with the evidence, the fact that they were called into that location for a reason. They went there with a reasonable suspicion. A description was given, fulfilled that with the gentleman here, that Mr. Miller, and then they further investigated the situation with him and recovered the suspected narcotics on this person. He did admit the fact that he dropped a pill at the time and that suspected cocaine was also recovered from this felon. It was placed in lock seal. I have that final lab. I can present to the court if the court allows, and go from that point in time. But with regards to the initial stop, Judge, the reasonable suspicion was apparently had by these officers and investigated this gentleman and then located a weapon at that location.
Your Honor, just very briefly, before I heard the testimony, I don't think there's been any testimony to show that my client committed any crime whatsoever. There was testimony from officers that they saw him somewhere in that store at some point in time, but there's also testimony there were 4 other persons that were inside of the form of the store at that point in time. I mean, you could argue that maybe the people that worked there hid the gun underneath the carpet box. I don't know, but there's nothing to associate my client whatsoever with that at all. That the police officers had full view of him. They looked at him, they didn't arrest him or anything of that nature, but they took him outside, they searched and they found no weapon on this man whatsoever. Telephone maybe that they didn't mention and stuff they found him or whatever. And then some suspected, whatever it was, could have been an aspirin, could have been whatever, Tums. I have no idea what that was. There was nothing to indicate that. So, Your Honor, I think that the prosecution has failed in all respects to show that my client committed any crime whatsoever. And just based on the law, I think that this court should just give us the benefit of the law, not the doubt, but the law. And the law would say that they've not carried the burden of showing that my clients committed any offense whatsoever, and these charges should be dismissed. They just didn't carry the burden. There's nothing here.
What's your position on Rudy's motion basically to reopen?
You know, naturally, I'm gonna say I objected. I mean, he's a seasoned prosecutor. I love him dearly. He's a good man. But I'm sorry, that's his job in order to be able to introduce certain things. He failed to do so. So at this point in time, you know, I think this court has to rule based upon that. He wants to reissue and then come back and do it for that, and that's up to him. But I think as far as his proof or closed, he said to the court, we close. So once he closed, it's closed. Respect.
Well, Judge, I think we've given at least a good reasons to reopen that proof for that final MSP lab.
What?
I'll allow you to reopen as to that issue only. You have it?
Yes.
So to Mr. Reed.
Can you approach, Judge?
Yes.
Like where they're waiting.
All right. Mr. Reed, I give you argument, additional argument, allowing to reopen the case.
Again, Your Honor, we just indicate the record that the proofs were already in. Everything Mr. Moody wanted to bring in the record for the court to consider was in fact supposedly given. And at that point in time, then I was asked whether or not I had any proofs, and we indicated we did not. So it's closed at that point in time. It's almost like having a trial and after the trial coming back and saying, oh, I forgot something. I don't think that's appropriate in terms of opening proof. If it had been an officer, I mean, if it had been a lab tech or somebody here and they were going to testify or something like that, that's a different story. Based on what has happened, I would ask this court to not allow that to be considered.
Should we bring it under 76611B?
I understand it. I mean, I allow them to open the proofs. I mean, because it's just a waste of not only the police officer's time, but the court time, et cetera, everybody's time to, to not allow it in. Mr. Moody is a seasoned prosecutor. I understand that. He's been around probably almost as long as I have.
Me too.
But we all sometimes slip. Let's put it that way. So, and that's why I allowed it to come in. All right.
Hey, guys,
I'm
I appreciate it. And it was coming in, Your Honor, in terms of what the court would use it for, the way that we didn't get the record that it's not even a gram, I think, of drugs involved. So I think these charges, I think they count as possession.
Charged with simple possession.
Yeah, possession. Not P words, it's just possession. And I guess the irony argument be use or something like that, such a small amount could easily be used, so I don't know whether it elevates to the point of actual possession, so that would be my only argument.
All right. All right, court having heard the testimony and arguments finds as follows. First, court heard from Officer Colin Schwartz, who testified that on May 12, 2023 at 1 East McNichols, which is a gas station. He was on patrol. He was in a scout car, semi-marked, uniform. Right there. First, we heard from Officer Sean Schultz, testifying on the same date, May 12, 2023, in the location of 1 East McNichols, City of Detroit, which is a gas station. He was in a scout car, fully marked car, in a full uniform, went to the location to assist. He searched the gas station. He found a weapon in the gas station. The weapon was in the coffee or under a coffee maker or in the kitchen type area. The black pistol, a Taurus. He placed the gun on evidence. He informed the other officers that he had located and found a weapon. When he got there, the defendant was not at the location, at least not inside the gas station, that he saw there were at least a couple of the patrons, the clerk, and officers in the gas station when he arrived. He did see the defendant. He was out front in the parking lot. We heard from Officer Colin Schwartz, who testified the same date, same place, same location, that he was in a semi-marked vehicle, modified uniform, and when he arrived at the location, he had received certain information giving him information. He went to that location. He saw a person fitting that description was a defendant. He then went in, saw him at the front counter of the gas station. He observed him there. He went in, he followed him outside. He then detained him. So at some point he was arrested, at which point he was arrested, he was searched. So from his first contact with the defendant throughout, he was with in his eye view and with a police officer. Removed from him was 4 to 5 tablets of suspected ecstasy and 1 Ziploc of suspected crack cocaine. Both were tested and tested positive for methamphetamine and cocaine. Cocaine weighed out at 0.8833 grams. Placed on locked folder N0057491155. He was then arrested. The court, I mean, there's no, even with a circumstantial case, you have to connect the dots. You have to connect this defendant to this weapon. And that hasn't been done at all. You got no one that says that he had a weapon, that they saw him dispose of this weapon, they saw him put it over there in that area. We're missing those dots. So as to the felony firearm, counts 2 and 4 and counts 5, the carrying concealed weapon, those matters are going to be dismissed. As to counts 1 and 3, possession of the methamphetamines, or ecstasy, and possession of cocaine, the court's going to bind those over. Find that those felonies didn't occur in the city of Detroit, probable cause of discharge as defendant. Will be bound over the Wayne County Circuit Court's Criminal Division for further proceedings. The arraignment on the information is going to be July 21st at 9 o'clock.
Thank you, I appreciate it, Judge.
Thank you.
Thank you.
May I approach the court?
Yes, sir. Thanks, that's your,
Mr. Reed. Dismissed on was dismissed 2, 4, and 5, Judge?
There's 3 counts.
yeah, yep, 2, 4, and 5.
Yeah, 2, 4, and 5. Yeah.
All right.
You don't need to send out. He's gonna sign his paper. We're gonna step outside. Stand.
What's your state of birth?
What's your date of birth? 12/5/94. 12/5/94.
Sir. All right. Okay, you can wait outside.
Okay, we'll pass that. Thank you. Have a nice weekend, Judge. Stay
All right, you
safe.
too.
All right.
See. Why you step up to the table or?
Parties ready on Sean Howard? Calling case number 2355849, the people of the state of Michigan versus Sean Howard. Defendant is charged with count 1, robbery armed. This matter is scheduled for a exam.
Good morning, Your Honor. Assistant Attorney General Philip Jock for People, P73754.
I'm sorry, I can't hear you. I mean, could you just speak?
Speak into the Assistant Attorney General Philip Jock for the People, P73754.
Judge Lawler for Mr. Howard, ready to proceed, move to Western.
You're joining that sequestration.
All right. You know, witnesses testifying today at trial or anytime in the future will be in courtroom, Zoom, and or YouTube, or deny their future testimony. Are you good?
Thank you.
your name, please?
Didn't say.
Thank you. Mr. Schaefer, can you raise your right hand? You swear or affirm the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Put the door right in. One second. All right, Mr. Schaefer, you're gonna be asked a series of questions. First by the prosecutor, and the attorney, assistant attorney general in this case, and also then by the defense attorney. Then I may or may not ask you questions, all right?
Yes.
You have to answer all your questions out loud verbally using words.
Yes.
You can't shake your head or just say, you have to say yes, no, whatever you answer, right? Also, when you're asked a question, I need you to answer that question and stop. If it's a yes or no type question, just say yes or no and stop. If they need additional information, they'll just ask you another question, all right? We all have a tendency, when we talk about something, especially if it's been traumatic to us, we tend to ramble. Because we want to get the whole story out. We tend to say, this happened, and this happened, this happened, and this happened. If you do that, I'm gonna miss something. If I miss something, I might not make the right decision, okay? I know nothing about this case. Only thing I know about this case is the defendant's name and what he's charged with. Now, I know your name. That's it. I get all my information from what happens in court. That's why we proceed one question, one answer at a time. That way I can understand what happened. Okay?
Yes.
All right. Thank you, sir. May proceed.
Thank you, Your Honor. Can you please state your name for the record?
Didn't say.
Mr. Schaefer, I'm going to direct your attention to September 25th, 2021. Do you recall that date?
Yes.
And on that date, did you come to be at the MGM Grand Casino on 3rd Street?
Yes.
And that's in the city of Detroit, Wayne County?
Yes.
What were you doing at the casino at that time? Gambling? And what type of gambling games were you playing?
Blackjack.
And were you using casino chips for this?
Cash and casino chips.
And approximately how much in casino chips did you have in your possession at that time?
Probably maybe 7,000.
And at some point in time, did you approach a cashier's window or anything like that?
Not at that time, I was gambling.
Okay. Let me back up a second. Was there a point in time where you stepped away from the gambling table?
To cash in.
And you still had chips, these casino
Yes.
chips in your possession?
Yes.
Were you approached by someone at that point in time?
Never.
At some point did an individual approach?
People that probably talked or something, but that was it.
Was there, did you get into an altercation or anything like that?
When it was time for me to leave, yes.
Okay, so let's get to that point. You're at the point where you're going to leave. What are you doing?
Going to the cashier thing to cash out.
Okay, so you're going to this cashier's. Is this a window or?
It's a window, yes.
You're going to this cashier's window to cash out. You said you have your chips in your possession at that point, obviously, that's correct?
Yes, my hand, pocket.
What happens at that point when you approach this window?
Someone was coming behind me and talk about you won, something look out for them, or something like that. Like, why look out for you?
Okay. And what happened after that person made that statement to you?
They just kept being aggressive to me and coming up to me and stuff. And I put the money up there to the cashier thing.
When you say money, you mentioned cash and casino chips.
The casino chips, yes.
Okay,
Because you can't put money.
Okay, so you put those up where?
On the desk to the cashier.
Okay, in front of the window you were describing?
Right there in front of the window.
Okay. And
cigarettes, everything I had in my pocket. They took cigarettes.
what happened after you set those items on?
They kept talking. I guess he got aggressive, or mad or whatever, then he wanted to fight. He kept running up on me and I'm defending myself and he got tired of me defending myself and when he got razors, I was mad.
I'm gonna back up for a second. You said he was running up on you. Can you describe to the court what you mean by that?
approaching me.
And approaching you and, is he doing anything at that point?
Yeah, talking that trash to me.
Okay. What kind of things is he saying to you?
Today, this day, I can't remember, but it was very aggressive.
Okay, so he's saying aggressive things. So
Yes, and my defense got on.
Okay. And then you mentioned, that he grabbed something.
That was after, I guess he got tired of trying to, come at me.
No guess what, just say what happened.
Okay, he kept coming towards me, kept coming towards me as the swings was going.
When you said he.
The swings, like one fight, come on.
Okay, so this person is swinging at you? at this
Yes.
point? Okay, swinging what?
His hands,
His hands.
you're running up at me.
All right. Does he have anything in his possession, like in his hands at the point that he's swinging at you?
At that moment, in probably say 2-3 minutes, he got tired of it. So he went back to his book bag and came back with 2 razor blades in his hand, razor blades in his hand, swinging.
What happened at that point?
I put my shirt around my hand and approached, come on.
Okay, so
And he just got tired, ran over there, grabbed the money off from the cashier people and ran out the casino.
okay. Let's back up for a second. You said he had the razor blades in his hand. What was he doing with them?
Swinging them, coming, approaching me, swinging them.
And at the point where he's either, you described how he was swinging at you first with just his fists, right? And then he was swinging at you with his hands, or with the razor blades in his hands. At any point in time, was he saying anything about,
Yeah, I'm gonna beat your ass, I'm gonna take that, this and that, excuse my mouth.
he said he was gonna take something.
Yeah,
What was he saying he was gonna take?
eventually this is my money that I have.
Okay, so he was saying he was gonna take your money.
He didn't specifically say, I'm gonna take your money. What are you taking from me?
Okay, but that,
He
said
took
was
all
gonna-
the money off the counter and ran out.
I just wanna be clear, he said he was gonna take something.
Yes,
Okay, and then you said it, after he said that, he was swinging the razor blades, then he took the chips from the counter, is that correct?
all this was going on at the same time.
Did that man have permission to take, your chips?
No, never.
Do you see that man in the courtroom here today?
Sitting right there.
And, he made a gesture, I'm gonna ask that you, point him out for the court and identify him by an article of clothing that he's wearing.
This green right there, the short hair he had, he cut his hair, but I see that face right there. He cleaned up right now because of the tops.
Your Honor, I'm gonna ask that the record reflect identification.
Right, that's all he's saying.
Nothing further.
Mr. Schaefer, I'm gonna, 2 questions for you. I'll try to be as straightforward as I can, but if you don't understand my question, let me know. You were at the MGM just by yourself, not with anybody else, right?
By myself.
And you were playing blackjack before this incident occurred, right?
Correct.
Okay. How long had you been gambling for? About,
Repeat that?
how long did you been gambling for that day?
I might have been there about 3-4 hours.
Okay. Now, the gentleman that you see seated at the table, had you ever, before this incident at the casino, had you ever seen him before in your life?
Never.
Okay. Have you told the police about something that you saw at some store?
No, I don't recall that.
No. Okay. go to the witness church. For the rest.
What are you approaching him for?
Because I want to, well, let me ask you
This is a
this.
statement?
Yeah, let me ask you the question, Rich. Did you tell the police, did you tell the police what happened and sign the statement?
I talked to the police. I seen the guy probably at the store near the casino.
Okay.
Begging for change, like, through all my times. I look at everything around my surveillance around.
So
That's a long time ago. I don't, know.
I understand, sir. I understand that's what I'm trying to get out. So before the incident at the casino, that's not the first time you saw the gentleman. There was a time prior to the incident in the casino where you saw him at a store?
Never.
Did
You try to confuse me.
Didn't you? No, sir, I'm not trying to confuse you. Did you say in your statement that you saw him at a store before you got to the casino? Did you tell the police that?
Never, because I didn't stop
I
at
made
the store.
approach the witness. Sure. For record, it's a 3-page statement. I've got page 2. I want you to read, first of all, let me ask you, sir, is that your signature on the bottom of this page?
That's my signature right there.
I want you to read, I'll put an X by it, what I'm talking about, X. See the question and the answer there, where I X'd it? Yes, sir. Can you read that? Yeah, to yourself, please. Does that refresh your recollection?
This reflects my recollection, but I did this, the second part right here is, no, this is not right.
Did you read the statement before you signed it? I mean, the police wrote that.
They wrote that.
You talked and they wrote.
No, man, I'm so frustrated that day. I just wrote what I said and I seen. I didn't see nobody because I never stopped at no store going to the casino. I
Okay.
drove off the freeway to the casino. That's it.
So your testimony now is that you never saw him at a liquor store
Before time and scenes, before times. Because when I leave there, the casino, I go to the store.
Right.
I probably seen him right there by the store or something like that. But I never had problems with nothing. I mind my business, go.
Okay.
But at this time, that will happen.
I understand, but my question is do you remember seeing him anytime in your life before the casino? And I showed you where you said to the police that you saw him at a liquor store before you got to the casino, but you're saying that's not accurate?
Not before I got to the liquor store. It might have been 5 days before I seen him at a store. Before.
Okay.
You know, like I seen this guy before.
Okay, so you
That's
did,
it.
so there was a time that you'd seen him prior to the incident in the casino, correct? Is that
Yeah, I
correct?
paid attention to
Okay.
seeing him standing
Okay.
around.
Okay, fair enough, thank you. Okay. But you didn't have any, other than just seeing him, you didn't have any interactions with him to the day of the incident, right?
To the day of that incident.
Okay.
That's one thing.
Right, so he was just somebody on the street who you'd seen before.
Mm-hmm.
Okay, all right.
I don't know.
So now, is there like a line, you go to the cashiers to cash out, you were coming with chips, obviously, playing black,
Yes.
right? And you approach, you're done gambling, so you want to cash out, right?
No, I wanted enough, and when it cashed out, I put some money in my pocket and keep gambling.
Oh, I see, okay. But anyway, you decided that you were gonna cash out some of your chips, basically.
Correct.
Okay. And
$5
the chips that you wanted to cash out, you put on the counter at the cashier, right?
Yeah, all of them that I was leaving that night.
Do you remember, were they black chips?
They was black, they was purple, I don't.
Okay, okay.
Get the camera, look at it.
And you're thinking that was about 500 that you put on the table there?
No,
I mean, not
it
table,
was about 6,000
that you were cashing?
that I was cashing, like 6,000.
No.
I had like 4,000 in my pocket cash.
Gotcha. Right, but that other 4,000 stayed in your pocket, right?
Correct.
So the 6,000, it was about 6,000, right?
It might have been more.
Okay, okay, so you put that on the counter. Now, is that when the gentleman
Is that when you first became aware of the gentleman? Was it before or after you put the chips on the counter?
When I put the chips up to the counter, as I'm approaching the counter, I put the chips there.
Okay.
He's approaching, talking to me.
Was he in line? Was there like a line?
I'm walking to there, he's walking on my left-hand side, following me, just looking at me, following me, walk up there. I sit it there, take everything out of my pocket, cigarettes, everything, put on it, cash right here. And as he kept talking to me, my defense guy, leave me alone, sir.
Understood. Okay.
And I guess he just got aggressive, his trigger just went off and he came toward me. I bagged away. The money's sitting there. We went what we do, whatever.
You say money or chips?
The chips, sir.
Okay. You say money, that's.
Okay, we have the tokens.
Tokens, okay. So once you had put the tokens on the counter to cash, there was a cashier standing there too, right? There was a cashier, right, okay.
They was in front of me.
Right. And then the gentleman started saying things to you, and then you basically told him to get lost.
Basically.
And then that's when he started, you're saying getting aggressive. Was that just, at that point, was that just verbally? Like he started to verbally get arrested? He didn't touch you at that point, right?
He was running up on me to touch me.
Well, but he was just verbal at that point, right?
He was running up on me to touch me. I don't know what verbal means.
Voice, he was just talking to you in an aggressive manner, right?
Correct.
Okay. So, does the cashier ever try to grab onto the chips or slide them under the window?
No, they were sitting there looking.
Okay. So now you're saying the gentleman at some point grabbed some razor blades? Is that what you call them?
Yeah, after like a minute or two, he ran back to his bag, because I gotta go back to the counter. Okay. He ran to his bag, opened his bag, he said, I got something for you. Opened his bag up and came back with the razor blade, swinging them at me.
Where was the bag sitting?
He put it over there for the chair. Look at the camera, you'll see.
Okay, I'm just asking what you remember, sir.
I remember that.
You saw him go to a black bag and grab some razor blades?
Yes, he went to his book bag and grabbed some razor blades.
You said 2 razor blades?
Whatever razor, he grabbed something. I'm paying attention to what I seen.
Okay.
The blades.
I just want to know. Okay, which hand or hand?
Both hands.
He had a razor blade in each hand.
He had something in both hands. It was a razor blade I seen for sure. And then the other one, so I'm paying attention. I don't take my eyes off the hands. I don't need that.
Okay.
I pay attention to what is in my face.
And when he pulled the razor, he had a razor blade in each hand, and I'm guessing you backed off at that point.
After he kept swinging them, after coming towards me, swinging them at me with my coat wrapped around my arms for him to cut this and not me.
Okay, so he had a razor blade.
And he got tired.
He had a razor blade in each hand and he's swinging at you. But at some point in time, he goes and grabs the chips off the counter.
Yes, indeed.
But at that point in time, he did not have the razor blades in his hand anymore, but he's grabbing for the chips, correct?
He put his stuff in his pocket, whatever he does. Did what he wanted to do. I'm not gonna run and chase behind him.
I'm only asking what you remember and what you saw. So,
that's what I did. That's what happened.
Did you see him grab the chips?
Yes, indeed.
So when he grabbed the chips, he didn't have the razor blade still in his hand. He grabbed the chips, correct?
You got 2 hands.
Exactly.
Understand? One hand can do more than one, but both.
I'm just asking you, sir. You just said
he grabbed the chips. As he moved it, whatever, but he grabbed the chips, and a lot of them fell on the floor, and whatever he grabbed with my cigarettes, he took with him and ran out the casino. And I don't know how the heck he got out of there.
Okay. But when you saw him take the chips, you no longer saw the razor blades in his hand. Is that fair?
When I see him take the chips, I wasn't looking for nothing. I'm looking for the police to come. He's away from me.
So then he leaves out of the casino. You see him leave out of the casino, right? In other words, he leaves the building, right?
I don't see him leave the building. I see him run that way. That's it.
Got it. What do you do at that point?
I stay right there for the people to receive my chips that I did not touch right there, because everything that I had in my possessions, I put on this counter.
Okay. Later that
they see everything else.
Okay. Later that day, did you see the gentleman again at some place outside of the casino?
After they arrested him.
Okay. And where was that you saw him?
They had me stay at the casino. They pulled back up like a couple hours, some hours later.
Okay.
Pulled back up with him in the back of the vehicle.
Okay, you stayed at the casino until that happened?
Yes,
Okay, so you saw the gentleman again in the back of a police car?
yes,
Was he just by himself in the back of that police car?
he was by himself.
Okay. Did the police ever show, before you saw him in the back of the police car, did the police show you any photographs any photographs to look at? Like, is that him or anything?
No, they didn't show me none of that.
Okay. After you identified him in the back of the police car, did the police ever show you any photographs ever?
Never. I don't recall seeing no photographs.
So so you identified him in the casino, and then you saw, can you believe the gentleman in the back of the police car?
The same voice, same hair, same face, everything I seen in the back of the car, and they brought him up to the casino.
A couple hours later?
Yes.
Okay, you said you heard his voice while he was in the back of the police car?
He got out the car, I'm standing while they take him out the car,
Oh, he
and
took him
walk
out?
in there.
Okay, so when you identified him, he wasn't sitting in the police car.
They brought him in a police car, he wasn't possessed. They brought him in a police car, they brought me out the casino,
Right.
said, is this the guy looking in the back of the car? Is this guy? I'm like, yeah, that's him.
Okay, so when you identified him, was he sitting in the car all the time, or did they take him out of the car?
Both.
Okay. So the first time you identified him, was he sitting in the police car?
Both.
Okay. Understand that.
In and out the car, sir.
Okay, so you identified him first when he was sitting in the police car?
Yes, sir.
Okay, and then you're saying you identified him again once they took him out of the police car?
Yes, sir.
And where, excuse me, where was he exactly when they took him out of the police car? Was he standing, was he sitting, was he on a sidewalk? I mean, where was he when you identified him?
I'm not being funny or nothing.
Okay.
You just asked me, was he sitting down? He was sitting down. Now he was standing up after they took him out. Which one? He was doing both.
But you identified him first when he was sitting in the police car, right?
Yeah, with the window down. I seen him. Right here.
Okay, did you hear his voice?
Yes.
Okay. But he was in the police car, you heard him say something?
Yes.
What did he say? Do you remember?
I can say it.
Well, yeah.
You punk motherfucker. You blind. I'm gonna beat your ass.
Okay.
I'm telling them to let him go, man. We can go on the fight right now.
Okay. So that, after he said that, then the police took him out of the car and had him what, stand up or what? If you remember.
They did something. I went back inside. Some other officers got me. I went back inside.
Okay, that's the last you saw of the gentleman.
That's the last I seen.
Till today.
That was it.
Till today.
Till today. Oh, actually, you know what? To be possessed,
No.
they did not take him out the car. I don't even remember, man. You know what I'm saying? My mind was just
Understood.
like, yeah, I don't even remember like
Okay.
that day of him getting out the car, in the car. I remember it when in the car, I seen the guy face to face, same voice, same aggressive, same everything to me with the officers. If the officers here, they can tell you the same thing because they were standing right there in front of me.
Was it like, what, was it?
It was broad daylight. It was like first thing in the morning. It was early. It was early.
Okay, so you spent the early morning hours at the casino.
I went there probably late, I don't know, late, but when I left and hung out there until all this stuff get investigated and everything,
Right.
when I left, it was early.
Like,
I don't remember. I got cussed out when I got home.
like early morning, like 4 o'clock?
I don't remember. I got cussed out when I got home.
Understood. One further question. Did the police or the casino ever show you any video?
They would not. They made me sign a paper for me not to sue them, and I should have did.
Thank you. That's all I had.
No regard.
Oh.
Thank you, Mr. Shea. Can you step down?
And I have no further evidence at this time.
No.
Ready to argue? Whatever. Your Honor, at this time I move to bind over the testimony from Mr. Schaefer that the defendant approached him, demanded something, and was initially swinging his fists, then brought out 2 razor blades and started swinging them at him. Ultimately took his casino chips and left the scene. He does have an independent basis for the identification, having seen the defendant on prior occasions, and did testify that he also observed the defendant at the show up after the police took him in custody. Thank you, Your Honor.
Well, with regard to the show up, personally, I don't think they should have put it in a lineup. So I think there's an issue there. Is the only gentleman sitting in the car there, is that him? But I think that kind of taints the identification process. Why not set it up, we got him in custody, do at least a photo lineup, not a live lineup. So I object to that and the identification issue. The only other thing I would note is that apparently, or maybe, or it wasn't clear that when he took the chips, that he still had the weapon, so the razor blades in his hand. Well, the court could consider separate offenses of assault and larceny. That's why I put that up as opposed to not harming them. My main concern is the police, when they didn't have a reason to, certainly could have set up a lineup. They didn't do that. So I think that taints the identification process. So for that reason, I move to suppress it.
Well, yes, Your Honor. First, the defense has the burden of proving that the identification procedure was unduly suggested in the case law. We don't have any evidence to that effect here. Second, even if there is an unduly suggested circumstance for the identification, the in-court identification is still admissible if there's an independent basis for it, and the witness testified that he observed the defendant on multiple prior occasions standing on the street corner. So in any event, the identification in court today is still good. And as far as the circumstances, counsel mentioned, well, we should have done a photo array or something like that. We didn't get into testimony from it, but the circumstances were that they canvassed the scene for a suspect fitting the description. They found the defendant in a close radius to the casino, did a Terry frisk of him, and found a box cutter on him. So they didn't have probable. I'm not arguing that for the bind over purpose. I'm just saying an explanation as to why they didn't do a photo array, because they didn't have probable cause to place him under arrest at the time. They had a Terry frisk, and they could detain him for a short period of time, and that's when they did the show.
Well, Judge, none of that was part of this exam. I don't think that should be part of his argument unless you wanted to put police or the casino.
I can't consider that. So, all right, I'm ready to roll. Before having heard the testimony, I find as follows. September 25th, 2021, that Mr. Dennis Schaefer went to the MGM Grand Casino on 3rd Street, City of Detroit, with gambling and blackjack. He owed $7,000 worth of chips and also additional cash. He was there for 3 to 4 hours. He went to cash it in so he could leave. That when he did so, someone came behind him, started saying, "Look out for him," or "Look out for me," whatever you want to call it. That Shaver responded, "Should I look out for you?" He kept approaching him, saying aggressive things. Person he identified as defendant doing this. He got to the window, the cashier's window, set the chips on top of the window along with the cigarettes. I guess some other things. Defendants then became even more aggressive, started approaching him. He then started swinging at him. Lasted for a minute or two, at which point he then went back to his book bag. He brought out 2 razor blades, held them in his hands. He was swinging the razor blade at the witness. Then turned back, went over to the window, grabbed the chips, along with the cigarettes, etc., and ran out. Mr. Schaefer stood by, waited for the police or security to come. He was told to wait there for a couple hours. Within a couple hours, he was told to go out outside where there was a police car. He saw the defendant sitting in the police car. The defendant then made some other comments to him about he was going to saw him, etc. He said it was the same person, same voice, same anger. He identified him in court, so it was more than enough for the for identification. I wouldn't stress it. Just, they're not required to do. This incident, or the defendant was stopped and picked up, arrested shortly thereafter this incident. He was brought back and then identified by the witness at that point. I don't see that as being tainted. Not necessity that they do a lineup. They normally do that when it happens an extended amount of time afterwards. Or court finds that the felony enumerated complaining warrant did in fact occur in the city of Detroit. Probable cause exists to charge this defendant to be filed over the Wayne County Circuit Court Criminal Division for arraignment on the information, which will be July 14th at 9 o'clock.
Thank you, Your Honor. Okay.
I got all that.
Counsel, do you have his? Sorry, Counsel, what is your P number?
737.
737.
5.
Make sure I had it right.
Thank you. Do you know which judge the POI is going to be in front?
Yeah, we want to know.
It hasn't been determined yet. It might go to do a trial. Probably have it on.